wanted her to do. He's got $10 million cash available. She's not committing herself to saying, but it's here at this bank. And at the same time, it's leaving it open. She's not totally relying on Ahmed because she understands they haven't finalized anything about a partnership yet.
But because the jury wasn't supposed to consider anything other than cash, does that make the letter or other or any other evidence more than a scintilla that either that Mr. Mehta was committing some sort of fraud or otherwise putting forth sort of a partnership a little bit, but then backing away when he didn't need it? I think that was, you know, I'm glad you raised it, because that was very confusing to me, was what we get to do, because it was in there a little bit, this notion that the seller was considering more than just cash, but I never quite figured out what the jury got to know and rely on and what they didn't. Does that make sense?
Yes, it does. So the jury was not instructed that you can only consider cash. It's just what was in the evidence in front of them. But and if there were fraud, if you want to try to construe it that way, the fraud would perhaps be on the bank, not on Mr. Ahmed. You know, the bank's the one who wrote the letter. But as we talked about a moment ago, I don't think it made any difference to the seller, so it's kind of like no harm, no foul. But the banker had seen, and the broker knew, and this is in evidence, that bench exhibit, the second one, defense exhibit 46, is from the broker explaining Mr. Mehta's got great references. Everybody thinks he's high integrity man. He's done other projects and loans for Chase. He's paid off a $10 million loan to Prosperity Bank with never late on a payment. Prosperity is even interested in writing this loan. So Community's not the only game in town. He's talking to other people who are expressing interest. She knows from another due diligence that's in evidence, he had several residential projects, several commercial projects, and we even got into evidence over their objection, but the judge did let this in. He has a cash flow surplus of $750,000 per year. Pay some interest payments for most of us. So there was a lot of evidence there to explain why the seller would have decided by June 30th, this is our guy, and why the banker would think, well, I can keep a customer happy by giving him this letter. I'm not really committing the bank to anything particular or to Ahmed. I think it all makes sense in the context of the evidence, which City of Keller says you do consider all the evidence when you're deciding if inferences are reasonable or not. The final point would be about fraud, and we've raised a lot of points about that, but after the briefing in the case, this court came out with Wood versus Wiggins, which is the third exhibit in the bench exhibits. Justice Guerra wrote that opinion. And it built on Sewing versus Bowman and Justice Brown's, I guess, concurrence maybe in that case, to explain if you're doing a partnership that says we're going to invest in real estate in the abstract, and we're going to have a partnership, that doesn't have to be in writing. But if you're doing a partnership that says we're going to have a partnership to buy this particular property, it does have to be in writing. And there is a remedy for people who trick you, take advantage of you, anything. It's just that you only get out-of-pocket expenses. You don't get a benefit of the bargain. Well, here, Mr. Ahmed's come in. He's asked, in his pleadings, he asked for the property. He even says, deposition, I don't care about getting any money. I just want to own either the Macy's or the mall. Just give it to me. Put list pendants on it. He kept the list pendants on the Macy's until we filed the supersedious bond from the judgment. And that's despite having testified at trial. He had no complaint about our buying the Macy's, which is why the jury went our way on the Macy's. But it's like, why did you sue about the Macy's if you have no complaint about it? Why'd you keep the list pendants on if you have no complaint about it? The result here is a huge windfall to a man who has contributed nothing, maybe a couple of meetings, a few phone calls, and that's why I think the law just forbids this. If he had out-of-pocket expenses, sure, we'd be in a different game, and I'd because of the standard of review, I might have to tell you, yeah, you know, I can't fight that. But when he's getting benefit of the bargain on this thin read, that's just not right, and the judgment should be reversed.
Thank you.
May it please the court. I'm glad that we started off with the discussion of the letter, because the discussion of that did not fit the standard of review really very well at all. Reading the evidence in the light most favorable to the appellee, Mr. Ahmed, and reading it in the light most favorable to what the jury actually found and the reasonable inferences that it could find tells a very different story. Here's what the letter actually said. And it says, this letter will serve to confirm that Meta Group has a good depository and loan relationship with the bank. Currently, they have cash of $10 million available. The word they either means Meta and Ahmed, because virtually all of it was Ahmed's, or it is simply not true. Now, trying to punt that to the bank doesn't work. First of all, this is what Mr. Meta, knowing full well what they meant, because he conceded at trial. No, I didn't have $10 million in cash available at Community Bank. I didn't even have close to that. I think at the time he had roughly a little over $700,000. And yet still submitted it with a cover letter that, by the way, says, this is what we have in one of our banks. Well, that's just not true unless it means both of them. But to create that letter, again, looking at the actual evidence that favors the judgment, this is what Mrs. McInnes actually testified. Meta goes in, as you know, and says, I need that proof of funds letter. And he just wants, which at trial, by the way, he tried to say, oh, this isn't a proof of funds letter, it's just a reference letter, which didn't make any sense. One of many, many statements that the jury, I'm sure, did not understand or believe, that just did not match up with the evidence. There was any number of things like that gave the jury any number of bases to not believe his testimony. But here's what he says. He says, I just want my name on the letter. Ms. McInnes says no because, quote, you're doing a partnership. That was her understanding, because as we'll talk about, I'm sure, in a minute, the very first time she talks to Mr. Ahmed and introduces this whole concept, he said, well, I'm not interested in being a lender. I'm only interested in an equity stake. So that was her understanding going in, that he wanted to be a partner, which is important to give the atmosphere to this. Now, when she said that, she said, no, I can't just put your name on it. It's not your money. You're doing a partnership. He doesn't say, wait a minute, we're not doing a partnership. What are you talking about? He doesn't say anything. He doesn't deny it and said, well, let's instead then just say Meta Group. This is one of many misleading statements used to get. Now, if you're a reasonable juror, you can easily look at that and say, well, she just said you're doing a partnership. That's something that should stand out, and say, well, wait a minute. If that weren't true, you would definitely correct that. So, instead, he allowed it to go, and that's how he got his hands on the proof of funds letter.
So are you arguing that the letter is an indication that there was a partnership?
The letter is
in addition to something else?
Absolutely. We actually think that there are any number of indications of an intent by both sides of holding ourselves out as partners. That's one. That's one right there. He certainly gave an indication to Ms. McInnes that, well, my understanding was correct. I was told by Mr. Ahmed that he was interested in being a partnership. I know they've been talking. I know they are talking about a partnership. And here comes Mr. Meta, and he walks in, and what does he say? I want the proof of funds letter. I raised the point, well, I can't just put your name because you're doing a partnership. And he says, okay, then we'll say Meta Group. And she then gives him the letter. No correction at all. And that's just, we have to bring this back to what did the jury see? Because what was being presented just a minute ago, and in the briefing and in the exhibit that was submitted as far as the timeline, is not the facts that the jury understood. It is not the facts in the light most favorable to their judgment. What's really going on here is a case of two completely separate stories, and it's fairly extraordinary. Sometimes you see cases where there's different perceptions of things, and you could see how that's somewhat reasonable. Here, you have Ms. McInnes and Mr. Ahmed, and by the way, that's important. We're the only one with a corroborating witness. Mr. Mehta has no corroboration for any of his story, which if you read it, I would invite the court to actually peruse it. At various times, I mean, it seems very clear that he's just making it up as he goes along.
But what do we do with, I guess here it seems like the question is, you know, there's partnership and then there's an agreement to agree to a partnership. And to me, this case seems very close to the line. And you do have testimony saying that, you know, we were going to do a partnership, or we hadn't gotten that far yet. And so it does, I guess, what are the pieces of evidence in your mind that tip that balance, that give us a scintilla to say, no, this wasn't just an agreement to agree, there was actually a partnership here?
Absolutely, and that's an excellent point too, because there's a lot made of that in the briefing. That, well, Mr. Ahmed, when he was asked, he's upset that they didn't get to a partnership. He says that a couple of times, or things in that nature. And as we said in our brief, it's like, but he also testified very clearly that he understood that they had a partnership at the time, and that there were objective indicia of a partnership. And so what do we do with those comments just before I get to the list? Well, that's for a jury. When a jury is faced with things that seem perhaps on their face inconsistent, the jury is the one that's entitled to reconcile those things. And here the jury was not confused at all. Let me give you a few examples. Here's one from Ahmed's testimony where he says, he said, Mehta promised that they would put, quote, the terms of the partnership that you formed into writing. That's at volume 6, page 209. The partnership meaning that they had already formed into writing. Because our understanding, which I think was clear at trial, was that when he's saying what you're really upset about is that you didn't get to that partnership, what he means by that is what he had said repeatedly. I was really upset that Mr. Mehta kept putting me off to get our partnership understanding into writing. It already existed, but that's what I'm really upset about. And they kept pressing on that, and now we're seeing it in the briefs as some kind of admission that, well, of course we don't have a partnership. If that were true, nobody would be here. And here's another example at page 150. He testified that he told Mehta that it was time to, quote, create a partnership agreement between us. So that's the agreement. But then explained, you could look at that and say, well, okay, so we need to create a partnership agreement. He must mean that they don't have a partnership, but that's not what he meant. And then the question was asked, well, why was it important for you to get an agreement, a written agreement in place? And he responded, whatever we have agreed, it has to be on paper so that nobody can have any conflict. Whatever we have agreed in the past tense. And this is one of several indications where he makes that clear. It's true. Mere personal belief, as the case is cited by the appellants, doesn't get you to a partnership. I mean, that would be someone would just say, well, I thought we were, and then it would be binding. Of course, that's not what we're arguing at all. What it does do, however, as I believe it's in West Side Record at page 169, what it does say, even someone's conclusory opinion, it does say that it's evidence of their own understanding. And so if nothing else, it's evidence of Mr. Ahmed's understanding that they presently had an agreement, and he's frustrated that they're not getting it to writing. Now, as far as what other types of things do we need to look at to demonstrate this expression of intent to be partners? Because this is ultimately the element that we're looking at, and I think there are any number of them. First of all, as we already talked about, Ahmed indicated to McInnes, the banker who was going to be at the center of all this, that he wanted to be a partner. He wasn't interested in anything else. And so that sets the stage for that. June 29th, Ahmed testifies. He told Mehta that he was only interested in a partnership, and that if Mehta agrees to be partners, then Ahmed's money, which is the key to all of this, is available. Mehta responds, well, then shall I go ahead and send an offer? No. Well, I'm not interested in being partners. Now, I know he just denied all of this on the stand. But here we're just talking about what did the testimony say. Well, he's then saying, if we have a partnership, I'll make my money available. He did make his money available, and that's how Mr. Mehta was able to go to Ahmed's banker, it also happened to be Mehta's banker, but it's Ahmed's banker and access his money. It's an extraordinary step. Normally we don't let people walk into our bank and get letters from our bankers based on our accounts.
But how do you square that with the broker, with her fairly, clear testimony that that letter didn't, not only did it not play a part, but she had no idea who Ahmed was when he reached out to her later, Mr. Ahmed, I should say, and what do we do with that, and what was the jury allowed to do with that?
Absolutely, because there's a lot of confusion there. We keep equivocating in the briefing between the broker and the seller. The broker made it very clear that at page 147 of her testimony, the ultimate decision was the owner, the seller. She made it clear, all she does is make recommendations. What ultimately happens is with the seller. And when testimony was elicited, as we mentioned in our brief, to try to say, well, what did the seller think about this letter that was objected to and sustained? She obviously can't testify as to what was in the seller's mind. The seller can change her mind at any time. In fact, in their own brief, at pages 70 and 76, they admit the seller could have pulled this deal at any time prior to the closing. That's crucial because that tells you the seller is the one in control, regardless of what the seller might have indicated. She might have said something like, well, I really like Mr. Mehta. I like where that's going. But I'm waiting for that data, which I made it clear I wanted. When the refinement letter went out, saying, here's what we want, because the offers that were coming in were not sufficient. We want to see something around the range of $10 million. We want a quick closing date of 30 days. And I want to see financials, audited financials, some kind of proof that you have the money, that it was very important to the client. At page 151 of her testimony, she goes through this because it's very clear that the seller wants to know that they have the financial ability to close right then. And it's also undisputed that up until that point, Mr. Mehta had not submitted that to demonstrate that he had $10 million in cash. That's what created this whole thing. He was in a terrible bind. His first two offers had been rejected. He had been specifically told, and by the way, he wasn't the only finalist. There were several others, as the broker talked about. The only thing standing in the way was that, wait, you've got to get this money and you've got to get it quick. If you wait 60 days, which is what he was going to have to do with bank financing, which is what he was counting on, you're going to lose it. You're going to lose the entire mall. Well, now you are in a unique situation which requires a unique remedy. You've got to find someone that has $10 million in cash right now and is willing to jump in immediately. That is a very rare, I don't have $10 million in cash. That is a very rare thing that you have to find, because these other guys are on their way and they're making calls. The broker says, I've been getting calls from them just as much as I've gotten from Mehta. So it's not just him. And so he needs to get from point A to point C, and he can't do it. And that's when he hears that he then just fires off an offer, okay, $10 million, 20-day closing. But he has no ability to do that at all. It's undisputed. He did not have $10 million in cash. And so that same day is when he calls Ms. McInnes and says, I need somebody with $10 million in cash. Do you know somebody? That's when she gets him in connection with Mr. Ahmed. And that's when he starts, because he is in such a desperate bind. He sees this as an extremely valuable asset worth at least $27 million that he can buy for $10 million, and he doesn't want to let it go. And so now he's willing to say, this is what the jury heard. They clearly believed that he was lying. They found that he had misrepresented in their fraud finding. But he also misrepresented in the letter that he sent to the seller. And then, of course, later we know that that letter was obviously very important, because he went to, and this is very clear testimony, extraordinary testimony from the banker, who said he tried to get me to bury this evidence. Hey, if you get called as a witness, let's just keep this between us. That is unbelievable testimony that from that alone the jury could discount just about everything. But now he's in this bind. He talks to Mr. Ahmed. Ahmed says, I'll do it. My money will be available, which will get you from A to C, keep you in the game, but only if I'm a partner. And he never says there's any number. And I'd like to reference a few of these. Here's all these indicia. We were talking about indicia. On June 30th, I've already mentioned the one on June 29th, which is when they talk first. He says, I'm only interested in the partnership. Mehta doesn't say, no way. He says, well then, he said, I'll put my money available if we are partners. This is at page 106 and 107 of volume 6. And Mehta then responds not, oh, I don't want to be partners. He says, well, all right, shall I go ahead and send that on? Can we move forward? And so now here's, if we wanted to know what's the evidence, and this is what really differentiates this case from many of the other cases that have been cited. What's the evidence that Mehta is now indicating that he is willing to be a partner? Well, here's one, because not only does he say, all right, well then let's move forward, he does move forward. He does, on that representation, go and get the proof of funds letter. Then on June 30th, this is at pages 111 to 14, he is invited, and again, he keeps calling. This is another problem in his testimony. He says, well, I didn't want anything to do with him at some point soon, but then he keeps calling. Like, why are you calling him if you didn't want anything to do with him? And the evidence there is all over the place. But on June 30th, he's invited. He invites Ahmed to come to his office. Then they go to the mall. And during that discussion is where you get the ownership split. Now, this is interesting.
What are they splitting? I feel like the testimony is unclear on that point.
I think it was undisputed that it was an ownership split. It was a 50-50 ownership split.
Ownership of the building or ownership of the partnership or?
Ownership of
Or
the
is
mall,
it a
the asset.
profit split?
The asset. From that, of course, is a right to receive profits. If you're an owner, you have a right to receive profits, which, by the way, is not gross proceeds. The cases that talk about gross proceeds specifically talk about gross proceeds, and the reason that that isn't profits under the statute is because employees are paid out of gross receipts, but only someone with an equity stake is paid from the actual profits. As any law partner knows, if you don't have profits that year, you're not getting any money, which is something I don't want to think about. But anyway, they get to the mall on June 30th. He says, would you like to do, Ahmed testifies that he proposes, we'd like to do a 50-50 on partnership on the mall. He doesn't say, I'm not interested in the partnership. He says, no, but I'll do a 65-35. Again, this is, he's leading him on, yes, we'll be partners at 65-35. When you're agreeing to these things, you can't then later turn around and say, oh, I never had any indication of a partnership. Then later, when he asks about getting the proof of funds letter, Ahmed points out that both of their names would need to be on it because, as he told Mehta, quote, Mr. Mehta, we are partners. And this isn't partners, by the way, as a lot of the cases talk about in just kind of general, we're partners, we're together. This is a very specific partnership for a very specific thing, for the purchase, acquisition, and running of the West Oaks Mall. But here's what he says. Because as he told, excuse me, Mr. Mehta, we are partners. That's at page 126 in volume 6. Mehta doesn't deny it. Here's another opportunity. He says, in fact, he doesn't do that. He goes and gets the proof of funds letter. Later, Ahmed testifies that he repeatedly agreed to put their partnership agreement into writing. So that's even more indication, if nothing else, that, oh, sure, we'll do that. We want what we've agreed. That's what the jury heard. We'll put into writing, but he keeps putting them off and putting them off and putting them off. Ahmed then testifies that he specifically gave approval for Mehta to get the proof of funds letter based on Mehta's agreement to put their agreement into writing, their agreement that already existed. This is at volume 6, page 127 28. He told McGinnis when he gave her approval to give the proof of funds letter, because she asks him about this, he says, he has agreed to do the partnership with me. Ahmed also testifies, we have a partnership agreement. Not we're going to have. We have a partnership agreement. This is at page 173 to 74. We have a agreement of partnership. That's why I want to have the proof of funds letter. Now, and there are several others. I've mentioned a few of them. And of course, again, he virtually confirms the importance of this proof of funds letter and what it really means, because what it says is things like they, our, and he knows full well that letter demonstrates that when you're talking about the funds of Community Bank, you're talking about both of our funds, and the vast majority of it is his.
And so what
what do we do with the testimony and, from Mr. Ahmed that when he was asked, as of July 17th, you understood unequivocally that you would not be going forward with any type of partnership with Mr. Mehta? True, that is true, and he answers that is true. What is
I'm sorry, on the
when
date?
when Mr. Ahmed was asked that as of July 17th,
Right.
he understood unequivocally that there would be no partnership going forward.
That's correct.
What do we do with that?
Well, what that would indicate, I see my time's up.
It's okay, I'll give you a couple seconds.
What that would indicate is, well, we had a partnership, it is terminable at will. That doesn't mean, however, it is not like an employment agreement. I mean, with an employment agreement, you owe no further fiduciary duty to someone, but with a partnership, when you have a specific identified, worked on opportunity, you can't just cut the person off and then say, okay, well, now we're done, so I get to do it on my own. That's one of the reasons why the whole Macy's thing is not even an issue. Macy's was a potential opportunity that only if it came up for sale. But that didn't come up for sale until September or October. But one crucial point is that Mehta never, and this is another indication, never, when he sent it to the seller, and by the way, the email, the broker said, well, I didn't think it was very important. The email that went to the seller from the broker attaching the proof of funds letter, put it in the subject line, Mehta's proof of funds letter. And so the jury could absolutely believe, sure, sure they're moving forward, they're doing that, it looks good for Mehta, but I want to see that documentation, and here it finally is. He did his tour on the 3rd, and the broker informed the seller, hey, he's done the property tour, I think at 1:41 p.m. All she says is excellent. She doesn't say, all right, award it. What she says is excellent. And then we don't get the award until after, it's undisputed, the seller gets the final piece, getting from A to C, the proof of funds letter demonstrating that the funds are there and accessible, and he never corrects that. Never. It's undisputed. The seller was always under the impression that that's where the money was. He never corrected it, and so that is more than a reasonable assumption for the jury to make, is that this had a huge impact going forward. Thank you.
So if I understand the argument is that Mr. Mehta defrauded the seller, defrauded the broker, defrauded the bank. I didn't hear a whole lot about defrauding Mr. Ahmed because there was simply no harm. He lets a letter be written. The testimony is undisputed. This is very important, page 5, volume 5, page 205. The brokers asked point blank, were you waiting on any other documentation? No. So you heard a lot of talk about audited financial statements and proof of fund letter and this and that. She's already saying on June 30th, I'm waiting for no documentation at all. As long as Mehta does the property tour, he is our guy. That decision was made. The rest of the argument, there's an overarching thing. The jury disbelieved Mr. Mehta, so that's a get out of jail free card. Texas law has long had a doctrine, I mean a long time, even before I was born, that disbelief of a witness does not establish the opposite of it. That's all they've got here. The best way to show this is the argument that you heard repeatedly. He believed they had an agreement. They had an agreement. They had an agreement. Okay, what are the terms of that agreement? 65-35 split. Whatever that means. But that's not the only factor. There are 5 factors. We know subjective belief's not enough. Schlumberger versus Swanson says, you know, it doesn't matter what you intend. You can call each other partners, but if you don't meet the factors, you don't have a partnership. Or you can sit around and say, no, we're not partners. But if you've got all the factors, then you are a partnership. They don't have any evidence of these other factors. This is just a made-up story. I'm willing to assume there might have been some miscommunication with language differences. I'm not trying to just accuse everybody of being a bad guy here, and even Mr. Ahmed. But he did admit twice, my complaint is that we never got to a partnership. The discussions never got that far. And he also admitted, I brought the lawsuit because I wanted to teach him a lesson. He jerked me around, so I'm teaching him a lesson. I don't think the law allows his claim. Like I say, Out-of-pocket expenses? Yeah, probably. If he can meet the proof for that, fine. But the benefit of the bargain of owning a third of this mall forever with no contribution, that's just wrong and the law doesn't allow it.
Thank you for your briefing and argument. The case is submitted.
All right.